So let's remain with this issue, which has generated topical headlines throughout the week. Let's go on the phone line and speak to private legal practitioner Martin Kpebu. Sir, you're welcome to ChannelOne Newsroom. Wontumi's lawyer, Kpebu, says the application for bail variation filed by the Director of Legal for the NPP, Gary Nimako, another lawyer, is the reason that his clients slept in custody yesterday. Can you explain to us how the law works, that if you're working on a bail surety and then someone goes to file a review of the terms of the bill, does that mean you have to be held in custody? Please help us.
No, I'm not aware. That is, it's a new proposition. I've done this work for a bit, but I haven't heard of such a proposition that just because the application was filed in court, the authorities will say, no, then let's wait and go to court. No, I think we should verify this particular fact. Because in actual fact, it sounds a bit, it's strange. It's strange. Because look, this is it. It's EOCO that has set its conditions. So if you meet the conditions, EOCO will go ahead and admit you, let you go, right? There's no need to wait for any court. It's very common to go file an application in court, but before the court sits, the accused would have obtained bail, or the suspect would have obtained bail. So you go to court that day and tell the court, oh, you've obtained bail. Then they want to withdraw the application. So this particular matter is strange to me, to be honest.
You have won landmark cases at the Supreme Court, which has defined our legal jurisprudence, one of them relating to bail. Can you educate us? Does what you got in the court include the fact that people should be granted bail on weekend or sent to court? What is the arrangement, and what could have happened or what can happen to him now that he's still in custody if they were to secure the surety?
Okay, yes. So as you rightly stated, the decisions are three. So you hear Martin Kpebu number 1 versus Attorney General number 1, Martin Kpebu number 2 versus Attorney General number 2, then Martin Kpebu number 3 versus Attorney General number 3. So use Kpebu number 4. The number 3 is a different matter. We'll leave that out here.
Yeah.
So briefly, number 1 is the surety's case. So hitherto, you see Brian Champon going to sign bail for Wontumi until 1st December 2015. Touch wood, if Wontumi were to abscond, instead of the police asking for the property or whatever Brian Champon used to justify the 50 million, and the state taking the 50 million from Brian Champon, they would rather ask him to produce Wontumi. And if after a period, and that one is not fixed, 1 month, 2 months, 1 year, bottom line, when the court's patience runs out and the Brian Champon was not able to produce Wontumi, then Brian Champon too would be convicted and sent to jail for 6 months. So there was section, this is 104, part of it, of the Act 30, that allowed the state to imprison the surety for 6 months. So in Kpebu number 1, that law was struck down. That's the imprisonment for 6 months aspect was struck down. But the rest of section 104 of the Act 30, that's the Criminal Procedure Act, is still in force. Then fast forward 6 months later, in May 2016, then Martin Kpebu number 2 versus Attorney General number 2 was also decided by the Supreme Court. So once again, the Supreme Court looked at it and said all the offenses that were termed non-bailable were about 12. So rape, defilement, narcotics, murder, treason, high treason, escape from lawful custody, piracy, etc. About 12 of them. If a charge on any of those offenses was slapped on a person, making him an accused person, he wasn't entitled to bail generally. So the Supreme Court struck it down and said now bail is at the discretion of the trial judge. You hear some people say it's a right, it's a right. It's not 100% a right. Yeah, it's a right, but subject to the discretion of a judge. So the judge will look at all the factors.
So it's not as of rights.
Yes, the judge goes through to look at all the factors and arrive at a decision to grant bail or not. Then there's Kpebu number 4 versus Attorney General number 4. That's the one that says 48 hours is 48 hours. So the court can sit on Saturday, Sunday, public holidays. I have been to court Saturday, public holidays a few times. So Wontumi could have been taken to court on a Sunday. But the difference is that in this particular case, EOCO had admitted him to bail, but it was the time, it took time for him to meet the conditions. So it's not easy to fault EOCO for not going to court within the 48 hours.
So
because
strictly,
they had admitted him to bail.
So strictly speaking, he's not in the custody or he's not in detention at EOCO. He's at the door. EOCO says you may go, but give me A, B, C, D. He's yet to produce that. So it's actually up to him now to get out of EOCO. That's simply what it means.
Absolutely.
And that's why there will be no need to put him before court. And that's why the 48-hour rule may not necessarily apply here.
Absolutely.
Interesting.
Yes.
Now,
Yes.
the issue of surety. So there seem to be multiple persons, we are told. We are told that the former Vice President, Dr. Mahmoud Bawumia, had secured some surety for him. Then we've also heard that Brian Champon has secured surety for him too. In fact, earlier we even heard that the Honorable Kennedy Japan has also secured surety. If all these people are coming up with their properties to stand surety for him, in your estimation, why is he still in custody?
That's $1 million question. So it's creating some, what do you call it? Some kind of disinformation, sort of, because the thing is that if somebody has already gone to EOCO and presented everything, EOCO would release Chairman Wontumi. You see, because now you hear some of them saying that other persons are frustrating the process. So it appears the MPP itself is using this Chairman Wontumi matter for some political campaign. That much is very clear because I don't want to name names, but there is tape where some lawyers have granted interview and said another lawyer has come to frustrate the process by filing the document in court. That process that has been filed in court, I don't see how it can prevent the release of Chairman Wontumi if only EOCO is satisfied with the properties that have been produced. That's the documents and everything given to them. So there is something, I think the MPP need to take their time and sanitize this situation. It doesn't look tidy at all.
Since bail and related matters are your pet peeve, maybe you should consider Kpebu number 5 versus Attorney General number 5, where you'd be looking at the threshold for an amount that will be set as bail. I do know that there are some crimes where the terms are stated clearly, but in this particular instance, people were saying 50 million is absurdly huge. What's your view?
Yeah, so not as an insult, but to make the point stick, the edge on our mind, let me politely say that opinion is also absurd. The opinion that 50 million is absurdly huge is absurd.
Okay.
Omaru, you are a student of the law. Soon you'll be a lawyer. Look, you see, lawyers comment based on facts. Now, we've not been told the amounts involved. So let's say the EOCO has told us that there is fraud, right? Money laundering, etc. We've not been told the amounts involved, whether Wontumi is facing money laundering involving 100 million, or it's just 5 million Ghana, or it's $1 billion. We don't know. We don't know. The same for all the other offenses. So once we don't know how much is involved, it's not possible for any reasonable person, let alone a lawyer, to say that it is huge. Rather, we should be pressing EOCO to give us more details, that just give us the headlines. What are the figures involved? So please, until we do that, please, anybody who tells you that this is absurd, the person doesn't know what he's talking about. How did the person measure? If maybe the facts had come out that the money laundering and everything put together come to, let's say, 3 million Ghana, and yet EOCO says the bail is at 50 million. That is where you can say absurd.
Okay.
But right now, you and I don't know the details. So where the challenge is in terms of our governance and how EOCO is handling it is that EOCO hasn't given us the details. Just that part. Next time, EOCO should do well to come out with that detail earlier. Otherwise, they'll get too much criticism, which may turn out to be unjustified. But because they didn't put out the right kind of information early, they will get bad press.
Do you think, though, that EOCO is duty-bound to tell us anything? Should EOCO come out and comment? What is the posturing of EOCO? And many people are even saying that your former committee member on the oral, Raymond Archer, they're saying that the way he's, in fact, people are even attacking his person, that he's not running EOCO properly. Should he be speaking? Should EOCO be saying something? What's your view? Is this another avenue of dispensing the oral work that you did at the EOCO? What's your view?
Okay, so number one, I don't think we should attack Mr. Archer yet, not the level of attack. Well, in Ghana, when you say attack, it depends. You know, in our democracy, it's expected that when citizens get frustrated, they'll begin to attack. But I don't think, yes, as I said, that failure to give that information is also contributing to this situation. But, you know, we are learning. I'm sure now, with hindsight, when they look at it, they will see that it would have helped. Because I can tell you, Mario, from the little I've heard whispers, not from Mr. Archer, I haven't spoken to Mr. Archer in months, not from him. I can guarantee you that the sums involved are huge, far higher than the 50 million bill that's been set. From Grapevine, I've heard figures. They are huge. Look, Cocoa Roads, I hear some stolen vehicles, etc. Right? The figures are huge. But is that failure by EOCO to name them, to put the figures out? That's creating this thing. But I don't think we should attack him yet.
Okay.
I mean, like we can criticize. Okay, certain levels of criticisms are permitted. Maybe they'll also learn how to, deal with this situation going forward.
Very well.
But I don't think that we should necessarily be targeting Mr. Archer. Archer is doing a good job, all right? Let's give him a bit of time.
Very well.
Right?
Thank you so much for speaking to us, sir.
Good. You're welcome.